The Housing and Planning Act was passed in June this year, and we now have had some meetings with the government where we've been given an indication of the implementation timeline. The Act itself introduces quite a range of measures that affect the private rented sector, from things like banning orders to a new fit and proper person test, and the possibility of things like new electrical safety measures and client money protection. If we start with the database of rogues and banning orders, we're expecting a consultation on the offences that might lead to a banning order to come out in October this year, and also the information that's going to be held on the register. We have some idea of the offences. The government were quite explicit when the bill was produced that things like sexual offences, crimes of dishonesty, violent crimes, as well as housing offences could see people either put on the register of rogues or indeed receive a banning order. We expect draft regulations to be published in early 2017, and implementation will be from October 2017. The government have tried to introduce new legislation either in April or October of each year, so we have some certainty about when new legislation will be enacted, and that's actually quite helpful. So generally for landlords now, when there's new legislation, the key dates are the 1st of April, funnily enough, I think we can all relate to that, and also the 1st of October. The Housing and Planning Act also introduces a new civil penalty regime. This is very wide-ranging. It will allow local authorities to issue civil penalty notices to landlords who breach housing offences, and the maximum fine that could be levied is up to £30,000, and councils will also be able to keep this money, so it's quite an incentive for councils to enforce. While we welcome the opportunity for councils to be able to both enforce be able to fund enforcement activities better, and also have new tools in their arsenal to tackle criminal landlords, we do have some concerns. The first is that councils might use this in order to target minor infringements, and we're hoping that the government will produce strong guidance to advise councils against that. We don't want to see landlords being fined £500, £1,000 for minor offences like dripping taps. On the other hand, we also don't want to see large fines being used as an easy route to target landlords who really should be prosecuted in the criminal courts. It may be a temptation for some councils to simply levy £25,000 or £30,000 fines on persistent offenders who commit serious breaches of housing legislation, and we're quite clear that those are the sort of people who should be getting prosecuted and who should be subject to banning orders. Again, guidance will be published in spring of 2017, and we expect implementation from April 2017. So that's just only a few months away, really, before councils can be handed these substantial new powers. And again, we'll be pressing to ensure that they're applied sensibly and proportionately. The bill also extends the scope of rent repayment orders. That now includes offences like illegal eviction and harassment, failure to comply with improvement notices, failure to comply with prohibition notices, breaches of licensing condition, and breaches of the new banning orders. Again, we'll see guidance in spring 2017 and implementation from April 2017. The new Act will also allow councils to data share. Principally, they're going to be able to access data from the tenancy deposit schemes, but it is also possible to be able to use other data that they gather for other purposes for housing enforcement. We welcome this. We think that the more data that councils have in landlords, actually the less need there is for them to go down expensive and ineffective licensing schemes. Councils already have a lot of tools for identifying landlords, including council tax records. The tenancy deposit records will be a potential new source of data for councils, and they should be using that data to identify landlords and to ensure that housing standards are enforced without the need to land landlords with expensive licensing fees that all too often simply get passed on to tenants in the form of increased rents. We're also going to see a new fit and proper person test. The scope will be extended to include immigration status, insolvency and bankruptcy, and also connected persons. So that means your business partner or your spouse, their conduct and their previous activity could be taken into consideration when councils are assessing whether you're a fit and proper person to hold a selective additional or mandatory licence. Again, we'll expect guidance in spring 2017 and implementation from October 2017. The bill introduces new enabling legislation. This is areas where the government haven't decided to act, but they've given themselves powers to do so if they wish. There's one area that's very welcome, it's client money protection. We've all seen cases where rogue agents have made off with money belonging to landlords and tenants, sometimes as high as six-figure sums. And client money protection would mean that any agent who doesn't have client money protection would be liable to prosecution, and also when agents do hold client money protection, then those landlords and tenants who previously would have been left out of pocket should now be able to recover their monies through the scheme. We very much welcome that. That's been welcomed across the industry, and it's been lobbied for some time, and it's really been quite inexplicable why the government hasn't chosen to act before now. It's very rare to get such unanimity across the sector from tenants groups, agents groups, landlord groups, local authorities, consumer rights groups. We all have supported this, and it's great to see the government eventually going to act on it. The other piece of legislation might not be so welcome. The government has given itself powers to introduce new electrical safety regulations. That may mean all private rented housing falling into line with mandatory HMO checks, which would require to be done every 5 years. It may set new electrical safety standards. Both of these we expect to see consultation on over the next year before draft legislation is laid. It's very important that landlords make their views known. What we don't want to see is a punitive electrical safety standard that could run into repairs of tens of thousands of pounds for landlord, renewed circuitry, new fuse boxes, whatever, when really actually generally speaking, the electrics of the property are fine. The biggest fire risk is really now appliances that are brought into the property by tenants rather than appliances supplied by the landlord or indeed the core electrics of the home itself. So we think this needs to be proportionate. And finally, there's one piece of good news from the Housing and Planning Act in terms of a new abandonment procedure. Abandonment is a very difficult issue for landlords. There's no clear process at the moment, and the safest way to end a tenancy is through either a proper legal process, a Section 21 notice or a Section 8 notice. However, sometimes properties do get abandoned, and landlords can be tempted to cut corners to avoid going to court simply by declaring the premises abandoned. And then tenants return and landlords can be found guilty of illegal eviction, harassment, and also have costs awarded to the tenant, and may even be required to rehouse the tenant in the property. So following a proper process is really important. At the moment, that process really is an eviction process. However, the government has proposed a new abandonment process, and it's an 8-week process. It requires there to be 2 months' rent arrears. It also requires the tenant to no longer be living at the property. Over that 8-week period, the landlord will have to issue 3 notices to both the tenant and any guarantor. And if at any point the tenant or the guarantor responds to any one of those 3 notices, then the whole process ends and the property cannot be declared abandoned. However, if at the end of the 8-week process nothing has been heard, there remains to be arrears in place, then the landlord can regain possession of the property legally without recourse to the courts.